Hello and welcome to another week of the Lost Confederacy channel. This is week 8 of the 13-week fiscal program for recovery for American prisoners of war. And here's always, we focus more so on that first letter in the acronym APW, which is American. And first and foremost, as always, we're going to start off with the militia video. I think it even hits a little bit harder now, especially with like some of the current events that just happened this past week. One being a photo of Jerry Jones. It's funny how the universe seems to give us topics that are in alignment with what we're doing as far as walking through this history of our military occupation on this land. And so without further ado, go ahead and play this video again of the Oath Keepers being infiltrated in pretty much every branch, every sector of this government. Channel. This is week 8 of the 13-week fiscal program for recovery for American prisoners of war. And here's always.
Center on Extremism is out with an in-depth analysis of a leaked Oath Keepers membership list from a year ago, which finds there were hundreds of names on it of current or former elected officials, law enforcement officers, and members of the military. The Oath Keepers are a far-right militia group, multiple members of which stormed the United States Capitol during the insurrection and that attack on January 6th. For more on this new report, CEO and National Director of the Anti-Defamation League, Jonathan Greenblatt, joins us now. Jonathan, thanks for being with us. So take us through the report that you all did, how you got your hands on the list, and what were some of the more troubling aspects of what you found?
Sure. Thank you for having me this morning, Willie. And I will tell you, this is a chilling report, the likes of which we've never released before. Last September, ADL analysts were able to get our hands on a data leak of the Oath Keepers membership rolls. There were 38,000 names that were essentially pulled from their records and put out in the open. Our analysts pulled down the information before the Oath Keepers could pull it back. We used open source techniques, including public records, social media, and other methods to review every single name that we found. And I must say, we thought the Oath Keepers were a threat when they rampaged through the Capitol on January the 6th, but we had no idea just how deep the threat truly is. We found hundreds of active law enforcement members who are part of the Oath Keepers, 10 chiefs of police, 11 sheriffs, dozens and dozens of active members of the U.S. military, some 80 individuals who were running for public office, almost 24 of whom made it through the primaries and will be up this fall. And look, you might not know all of these names. Many people might know Arizona State Senator Wendy Rogers, who still, months after the terror attack at the Capitol, proudly proclaimed that she was an Oath Keeper and supported the group. But I'm talking about a county commissioner in Nevada, a town justice in New York, a firearms instructor in Pittsburgh, a pastor in North Carolina, and it goes on and on and on. These are individuals with access and influence. These are individuals with resources and training. And these are individuals who have shown us they are willing to commit acts of sedition and violence against the U.S. government.
Jonathan, are you surprised at the extent of the membership of the Oath Keepers and other far-right groups who apparently, or maybe they do know, that the underpinnings of the philosophy of these groups are rooted in race and religion? In other words, they're against anybody who isn't white, And Jewish people obviously have a target on their backs based upon their philosophies. Does this surprise you at all that their membership is so diverse in a sense?
It somewhat does. I mean, look, right-wing extremism is a spectrum. We know that, Mike. And so there are white supremacists, there are sovereign citizens, and indeed, there are these armed militia groups. We know organizations like the Proud Boys, you know, Tario, the head of it, is Hispanic. And indeed, there is some diversity among the Oath Keepers. But I think what's more frightening is the fact that they, for a long time, have prioritized recruiting active and retired law enforcement and military. We thought, Mike, they weren't being successful. We were wrong. We have a problem with an enemy inside our own ranks who has committed, as the Oath Keepers do, to uphold a higher oath, not to have fidelity to our commander-in-chief or necessarily to the jurisdictions where they work, but to their notion of the Constitution and a holy obligation that, again, puts minorities, puts Democrats, and puts ordinary citizens in their crosshairs.
CEO of the Anti-Defamation League, Jonathan Greenblatt, thank you very much for coming on this morning.
All right, so again, as we continue to show that video pretty much each week, we continue to reiterate, this government, this system has been infiltrated at each level. You mentioned 100 and I believe 11 military or active military or retired military being found within this Oath Keepers list. And it just kind of goes back to the video we showed, I believe, with the Selma video of how Chief Blackcoat had pointed out that was the MP, military police. So nothing's changed pretty much since then. Still infiltrated again within this government, still infiltrated within the system. And it's funny to me how it kind of just all rhymes again with another topic that just highlighted or came out last week with Jerry Jones and him being pictured in a photo of some American children integrating into Arkansas school. Before we get into that, I definitely want to go ahead and bring up, because, you know, our people, their memory is not too well. We tend to forget everything if it's not being, you know, bombarded every day with it. So we see here on this map of Jim Crow America, this is Arkansas, one of those Jim Crow states. Jerry Jones pictured in that picture was in Arkansas. And I'm gonna go ahead and highlight that picture as well. See if I could pull it up here. Bring that up just so the viewer can see this. Y'all let me know if y'all can see it on the screen, if I need to blow it up a little bit more. So Jerry Jones right there. And I kind of bring this up too, because just shows the difference in how media coverage and media treatment is done for the European versus the American. We see Jerry Jones here pictured. We just read about 1957 Civil Rights Act, which is basically a study to pretty much integrate, stop Jim Crow laws, just a study of it. And this is actually in 1957, so that same year. And it also just rhymes with how every time there is an act that, again, isn't specific for us, but is, you know, among our scholars is supposed to be for us, there's always something that transpires as well. So in 57, we have the, what was it, the Little Rock Nine. This wasn't these actual children here, but again, another high school in Arkansas. Believe in 65, what was it, Malcolm X was assassinated. 68, we got Martin Luther King assassinated. 68, we also get the Civil Rights Act. So it's always funny how these tragedies or these events occur, and then, okay, here's something for you all. But again, it's not specific, because the question of our existence with this whole thing is, who the fuck is civil? Jim Crow laws, we pull that up as far as who they were being targeted to. It was Negroes, Blacks. There's being very specific in who they made these laws for. If you don't believe me, I'll go ahead and have a quick reminder for you all. What white, colored, what is this? Nurses, Negro men. So we see that they're very specific when it comes to their Jim Crow laws, as you say, which is at the state level. But when it comes to, the federal level, nothing specific at all. So if the civil rights is for us, let's see if I can do a quick search of if civil is in these Jim Crow laws. I think that says no results found. So again, this game that keeps getting played between the state level as well as the federal level, as Chief Alligator highlighted last week, we pretty much are that ping pong ball getting bounced between the state as well as the federal, but again, nothing is being done for us. So definitely wanted to highlight that. Anything y'all kind of want to build off before we jump back into these readings?
I think you pretty much covered everything. Again, it's just that we're going for just anything in regards to accepting what they give us. Like you said, like a ping pong ball, just going back and forth and nothing being specific for us, just being benign and neglected.
Yep, and to the people that's in the chat watching this video, feel free to ask any questions and engage as we move forward. We're gonna hit them with the other video.
Yes, sir. Yes, sir. That's just going to be a good little segue. Again, just saw the picture of Jerry Jones stopping some of our grandparents, great-grandparents from entering these schools. But again, that was just on a PG level. What was really actually happening is, dogs being sicked on children. Dogs being sicked on a lot of, the viewers, our grandparents, great-grandparents, great aunts, great uncles, things of that nature. So again, just kind of want to continue to keep that in the forefront, because unlike Stephen A. 65 years ago, but still we're seeing the repercussions of that till today. So go ahead and play this video.
Martin Luther King Jr. came to Birmingham, Alabama in 1963 on a mission to a place he called the most segregated city in the United States.
To dramatize this blatant injustice and to demand that the federal government not put a cent in this city unless it decides to face the realities of desegregation.
In the nonviolent demonstrations that followed, King and hundreds of protesters were arrested. They were pressing the city to eliminate laws that sought to keep Blacks and whites separated in schools, restaurants, and many other public places. Historian Robert Corley says King and the local civil rights leaders needed this strategy to succeed.
There had been no movement whatsoever in the city toward any form of desegregation of any of its institutions. And so King was saying, if we can win in Birmingham, if we can come to Birmingham and prevail, then we can win anywhere.
King and his followers were met with fierce resistance from the police. Public Safety Commissioner Eugene Bull Connor, backed by the majority of white residents, was determined to stop the demonstrations. Without enough volunteers to continue the protests, King and other leaders enlisted hundreds of young school children to keep the marches going and fill up the jails. The young African-American student protesters would gather here on the steps of the 16th Street Baptist Church and hear inspirational speeches from civil rights leaders like Dr. Martin Luther King Jr. They would then file from the church and walk across the street to a park where they were determined to demonstrate peacefully for equal rights.
I was arrested after we got about a block away from the church in this area.
Janice Kelsey was 16 years old when she and her schoolmates were jailed.
My mind was made up. I was going to participate. I was going to go to jail. I wanted to get my freedom.
Then on the second day of the student demonstrations, things turned violent. Police turned high-pressure fire hoses on the young people and set attack dogs on them. Birmingham civil rights leader Reverend Calvin Woods was there.
There had been some dog biting, some beating, some killing. Many people were beaten and spit on and put in jail, lost jobs. But those were minor things compared to what we felt we had to do.
The brutal crackdown was widely televised and images of the event were seen around the world. Robert Corley says this incident galvanized new support for the civil rights movement.
It was really that children's crusade that really turned the tide, because it did serve the goal of filling up the jails and forcing the white community to come to the table with King and negotiate some sort of settlement.
Eventually, King and Birmingham city leaders reached an agreement. Within months, the local segregation laws were abolished. Reverend Woods says King's determination to keep the movement going made all the difference.
But we would not have accomplished what we did if it had not been for the support and leadership that Dr. King brought.
The Birmingham campaign was a climactic battle of the civil rights movement. For many, it stands as an iconic symbol of the sacrifices made by King and thousands of African Americans. Chris Simpkins, VOA News, Birmingham, Alabama.
Right. But those who are at the back of the line.
All right. But again, right there, highlighting, you know, the acts that were done to children. Again, like I said, some of our grandparents, great grandparents, great aunts, great uncles, dogs being sicked on them, water hoses being sprayed at them. Like he said, some even died. But again, these are children. These are, again, if you're going to parallel this with Jerry Jones, 14, 15-year-olds. So on one hand, we have an excuse for, oh yeah, he was just 14, 15. They probably didn't know what he was doing, standing there, you know, trying to stop some Americans from entering the school, versus 14, 15, 16-year-olds getting attacked by dogs sprayed with water hose from this same government that you're looking for protection from. So it's no excuse at all. It just highlights the predicament we're in, and again, just highlights further that we are prisoners of war on our own land. What other group of people, kids, are getting attacked like that? As the viewer, comment, you know, engage with us. What other group of people have you seen go through that with their children? None, especially on this land. So with that being said, I'll let you kind of, if you all want to build off of that, while I go ahead and pull up this 1964 Civil Rights Act. Y'all good? Okay. Without further ado, I'll go ahead and I believe Chief Quietwater, you had this week's Inventor. Pull this up here. I think you're on mute.
Okay, so this week's Inventor. Just a moment. Okay, so this week's Inventor is Lloyd E Hall. And he invented the throttle position sensor. The patent date is November 12th, 1985. And the patent number is D281323. There wasn't any image of it, like the invention, but basically what it is it goes in your car, and it's a sensor used to monitor the air intake of an engine. The sensor is usually located on the butterfly spindle or shaft so that it can directly monitor the position of the throttle. It wasn't a lot of information on any background with him either, but Lloyd E Hall is the American inventor for this week.
Excellent inventor, excellent inventor. And do we own, or does his family own any percentage of that invention?
I highly doubt it, no.
Gotcha. So again, as the viewer, hey, we done created a car, we done created the refrigeration system to transport food across, this country. We done created so many things. So again, just highlighting again, we weren't slaves. Slaves aren't inventing things, inventing industries, things of that nature. This week, I want to do quote 8 from Dr. Carter G. Woodson. And quote 8 reads, "In the church, where we have much freedom and independence, we must get rid of preachers who are not prepared to help the people whom they exploit. The public must refuse to support men of this type, ministers who are the creations of the old educational system must be awakened, and if this is impossible, they must be dethroned. Those who keep the people in ignorance and play upon their emotions must be exiled. The people have never been taught what religion is, for most of the preachers find it easier to stimulate the superstition which develops in the unenlightened mind. Religion in such hands then becomes something with which you take advantage of weak people. Why try to enlighten the people in such matters when superstition serves just as well for exploitation?" I thought that was very key, especially for what we're going to be reading pretty much for the next few weeks, I would say, in regards to just seeing who these leaders were. A lot of these civil rights leaders were our preachers, were our religious leaders. And as we continue to read through these documents, we'll see what really did we get as far as tangibles, as far as resources out of these civil rights acts. So that'll be a question to keep in the back of your mind as the viewer. Who were the leaders at this time? What were we asking for? Of course, we know the ending of Jim Crow laws, but also what resources? Because yeah, we want you all to stop beating us, but we also need some reparations for what all we've endured. The burning of businesses, the burning of our towns, things of that nature. But was that implemented within these civil rights that, again, were supposed to be for our group of people? Just a question for us to keep in the back of our mind. And lastly, we'll have Chief Alligator with this week's, with the legal definitions as well as maroon historical points.
All right, legal definitions. First definition, American, indigenous to America. Number 2, descendants, one who follows in the bloodline of an ancestor, either lineally or collaterally. Third definition, slavery, a situation in which one person has absolute power over the life, fortune, and liberty of another. 4, prisoner of war, a person, usually a soldier, who is captured by or surrenders to the enemy in wartime. 5th definition, school, any institution at which instruction is given in a particular discipline. 6, education, an enlightening experience. 7, recovery, a return to a normal state of health, mind, or strength. The action or process of regaining possession of something stolen or lost. And the maroon historical points, number 1 was a person escaping slavery, seeking freedom, or breaking the law. 2, providing unity and a strong defense came first. 3, maroon leaders were first and foremost military figures. 4, maroons established guerrilla warfare, planting sharp sticks in thick grass. 5, maroons knew their European enemies' language, defenses, and plans.
Thank you. All right. And I believe on week 6, we had left off on the last paragraph up in page 2 here. Just a brief little recap, a summary. Basically was going over, I know the last thing that we read was going over pretty much how they would go about implementing some of these newly enacted laws to help with the implementation of desegregation, pretty much. So what we'll be going into within this next paragraph or so will be about, again, just discrimination, getting rid of that, and how they see to enact certain laws that will help with that. So I'll go ahead and start off with this one. In any proceeding brought under subsection C of this section to enforce subsection B of this section, or in the event neither the Attorney General nor any defendant files a request for a 3-judge court in any proceeding authorized by this subsection, it shall be the duty of the Chief Judge of the district, or in the absence, the acting Chief Judge, in which the case is pending, immediately to designate a judge in such district to hear and determine the case. In the event that no judge in the district is available to hear and determine the case, the Chief Judge of the district, or the acting Chief Judge, as the case may be, shall certify this fact to the Chief Judge of the circuit, or in his absence, the acting Chief Judge, who shall then designate a district or circuit judge of the circuit to hear and determine the case. It shall be the duty of the judge designated pursuant of this section to assign the case for hearing at the earliest practical date and to cause the case to be in every way expedited. So again, kind of what Chief Alligator highlighted a couple of weeks ago, none of this stuff would actually happen in reality. For one, they wouldn't even allow you to even enter into this court, let alone go through this whole procedure to even have your case heard. Even if you were to become, knowledgeable of this whole procedure. We just saw a whole video of them not even being able to enter into schools. Now we're talking about entering into a court of law to get justice from the same people, again, that were just spraying water hoses at your children, again, sicking dogs on your children. So again, this is all well and dandy in practicality, but in reality, it's a different story. Scroll down here. All right, so Title II, the injunctive relief against discrimination in places of public accommodation. So Section 201A, all persons shall be entitled to the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of any place of public accommodation as defined in the section without discrimination or segregation on the ground of race, color, religion, or national origin. B, each of the following establishments which serve the public is a place of public accommodation within the meaning of this title, if its operation affects commerce or if discrimination or segregation by it is supported by state action. So I just kind of stop right there. Again, all persons, I believe we looked up the legal definition of that. Pretty much that could be a company, organization, imaginary person, pretty much anything can be a person. But again, as we highlighted earlier when we're starting this video, Jim Crow laws were specific to one group of people, and that was the Negro, the colored, Black, whatever other reclassification term that they used at the time. So again, as we can see here, just in this section, all persons, they're pretty much, again, muddying the waters, opening up Pandora's box, but again, not being specific to who these Jim Crow laws are actually affecting, who is actually being discriminated against, who is actually being segregated, and things of that nature. Let me see here. Each of the following establishments, okay, number one. And in addition to any of these places that can't be discriminated, we also have here any inn, hotel, motel, or other establishment which provides lodging to transient guests other than an establishment located within a building which contains not more than 5 rooms for rent or hire, and which is actually occupied by the proprietor of such establishment as his residence. 2, any restaurant, cafeteria, lunchroom, lunch counter, soda fountain, or other facility principally engaged in selling food for consumption on the premises, including but not limited to any such facility located on the premises of any retail establishment or any gasoline station. 3, any motion picture, house, theater, concert hall, sports arena, stadium, or other place of exhibition or entertainment, and any establishment, AI, which is physically located within the premise of any establishment otherwise covered by this subsection or subsection II, within the premises of which is physically located any such covered establishment, and which holds itself out as serving patrons of such covered establishments. So again, pretty much what I just read was any restaurant, motel, place of entertainment cannot be discriminated against as far as its patrons or segregated. But again, that goes completely against what those Jim Crow laws were saying in regards to who was being targeted to not being able to enter into these restaurants, these hotels, these theaters, things of that nature. So again, as we can see here, just opening up Pandora's box, but again, not specifying who is being discriminated against in this federal act. Anybody kind of want to build off of that? And also any questions from the viewers, we can definitely go ahead and answer those.
Yeah, what we're reading right here, for me, what jumps out, what jumps out to me basically in this reading is when people say we need to do for ourselves, we need to support our own, what we have to understand is this would have been our grandparents. They didn't have any other choice but to create an Apollo in New York, if you will, which would be like any motion picture house or theater or concert hall. We have to remember the Little Richards, the James Browns, the Four Tops, the Temptations, the Diana Ross, the Motown. They could not go into European establishments. They could only perform for their own people. Really got to understand that. Desegregation or the civil rights movement, now it allows for our superstar artists to be honored or represent or looked at by Europeans. So we have to look at what was really going on. We had what they called a Chitlin circuit, and it ran all through the Jim Crow area in the South. We had our own little establishments, and I think Apollo was now torn down in 2022 in New York. Each state had its own special concert place where historically we had our legends go there. It also shows me military occupation, because if they had to be this specific and say that now, anybody can come to these places, then you got to reverse engineer that and say, well, what would happen if you did go to a motion picture house, a theater, a concert hall, a sports arena? What would happen to you? The same thing that Chief Biko showed on the video. They could sick dogs on you, spray you with water hose, beat your ass, kill you. I'll stop right there.
Yeah, just to piggyback off of that, just how specific they are. And very, very detailed in regards to what you could and couldn't do. I think that is just a red flag where we have to think, about why were they so specific. So I definitely think that this is just brings light to everything that we've been talking about to prove that we are prisoners of war.
Great points, great points. I'll pick up here, subsection C. The operations of an establishment affect commerce within the meaning of this title if 1, it is one of the establishments described in the paragraph 1 of subsection B. 2, in the case of an establishment described in paragraph 2 of subsection B, it serves or offers to serve interstate travelers or a substantial portion of the food which it serves, or gasoline or other products which it sells, has moved in commerce. 3, in the case of an establishment described in paragraph 3 of subsection B, it customarily presents films, performances, athletic teams, exhibitions, or other sources of entertainment which move in commerce. And 4, in the case of an establishment described in paragraph 4 of subsection B, it is physically located within the premises of, or there is physically located within its premises, an establishment, the operations of which affect commerce within the meaning of this subsection. For purposes of this subsection, commerce means travel, trade, traffic, commerce, transportation, or communication among the several states or between the District of Columbia and any state, or between any foreign country or any territory or possession and any state or the District of Columbia, or between points in the same state, but through any other state or the District of Columbia or a foreign country. So again, just highlighting how, as Chief Alligator said, as Chief Quietwater said, you have to kind of reverse engineer it. If we weren't able to go to these places and, frequent or traffic these places, what would happen? Another example will be shown in that video. You would have regular US citizens being deputized because they could just make up any law, because again, you weren't able to just walk up in that courthouse and just have any trial be done or have your case be heard. They were having, being the judge and jury and executioner at the same time. Again, so postcards of them having lynching parties in the towns. Nobody was frightened in those pictures. You saw people smiling, having a good time. And that was all because, again, being able to be deputized and because of military occupation. If you know you can get away with stuff like that and the military has your backing, or you can call upon the military or your officers or whichever, lower branch of that military occupation that you're dealing with in that area had your back, then you were good to go. You were good to go.
And it really hasn't changed to date, in regards to the killings and, police officer killings and things of that nature. Nothing happens to them. They get paid leave and they're right back at it. So it really hasn't changed much in that regard.
Correct.
We have to definitely keep that in mind when we give these, different events that happen. There's no excuse,
Yep, I was gonna add on to that as well. We see that today when these local municipalities kill us. You hear people who look like us on mainstream media talking about they hope the DOJ picks up the case, which would be the federal government. So you're no different than in the 1960s. At the state or the city or county level, they could kill you, and they knew the federal government wasn't going to send their agents in there to escalate the situation. We can look at Breonna Taylor as the most recent situation of that, where you got Grandmaster Jay indicted on federal charges, but that same federal government has already found that 3 of the officers had premeditated what they were going to do to her in the garage of one of their establishments, and they went and got a fake warrant. On top of that, he's in Louisville organizing with the local police about what they were going to do on that particular weekend. And now you got some deputized federal agents on the top of a building. They're saying he pointed a gun at them, but you got local authority all around as they're doing a dry walkthrough about what's going to happen the next day. But they can hit him with the overhand right because the state and the Fed have 2 different jurisdictions. So the state really can't say, oh, well, we were pre-planning with Grandmaster Jay that night. So there's no way possible he was going to hurt a deputized federal agent on the roof, because we're all out there with him. So we have to see that this shit is really bullshit. And for those that are watching this video, we got to remember to never forget. The Jews are showing us that right now. The gays, every other group of people are showing you that disrespect will not be tolerated. And the Jews are showing, no matter how flawed their history is, they don't even want you to punch holes in the flaws in their history. They're saying, watch your mouth. So here we are as a group of people. We won't even stand up for ourselves and honor our rich history. We have a very rich history with all the inventions that we've created, all the wars we've fought, especially in the South, never backing down. It just doesn't make sense at this point why we just don't shut the whole show down and just stop supporting it.
Great bill by both of you. I'm glad you guys highlighted that as well. And like you said, it just speaks to how other groups aren't willing to tolerate certain things. You mentioned, you know, the Jewish community, the gay community, and it just kind of highlights what our group is so willing to tolerate, and the lack of, not even the lack of power, but the lack of use of that power to get things moving. Highlighted again, Jerry Jones, pictured in exactly what we're reading about right now. But how many of you all are still going to say, you know what, 65 years ago, he was a boy, you know, still gonna rock that cowboy star on our chest. We're still going, you know, watch these games. Well, if you're going to do that, then you can't complain when, as Chief Quietwater stated, this shit continues to happen today. Just show you a video. 14, 15-year-olds getting sprayed with water hoses, getting sick by dogs. Hell, we can probably pull up a video quickly, 15-year-old getting shot by police. What more has to be shown and done to our group of people before we can say, or before we actually say, you know what, fuck all of this, we're not supporting any of it? What more, you know, has to be done? So I'll continue here on subsection D. Discrimination or segregation by an establishment is supported by state action within the meaning of this title if such discrimination or segregation, one, is carried on under color of any law, statute, ordinance, or regulation. So again, remembering color of law, basically being appearance of law, but not actual law. So it can actually be going against the law, which we already know is natural law. Or two, is carried on under color of any custom or usage required or enforced by officials of the state or political subdivision thereof. Or three, is required by action of the state or political subdivision thereof. So it's saying here, discrimination or segregation by an establishment is supported by state action within the meaning of this title if such discrimination or segregation is carried on under color of law. But they basically are just contradicting themselves, basically saying you can discriminate and segregate under the color of law. At least that's what I'm getting from this little section here.
Yeah, right now, anybody who watches this, if this is foreign to you, it's because they purposely don't educate our group on purpose. Everybody talks about the right to vote and tie that to the civil rights movement, but we're clearly showing you based on the document we're reading, this shit was about ending Jim Crow.
Mm-hmm.
This whole document is being detailed about untying Jim Crow knots. They just weren't specific at the federal level about who they were untying it for. And that's due to being denationalized through the Indian Removal Act and the unlawful Seminole Wars. Those that did not go into Oklahoma were able to keep were able to steal our birthright or keep it. Those who were really from the east of the Mississippi, and those that adopted in were able to steal our birthright. Meanwhile, those of us that never left and continued to fight and stand 10 toes down, we were reclassified, and we're still reclassified to this day by this government. They will not talk to you directly. They can't. There's nothing in their federal documents that make them have to talk to you directly, which is why anytime you hear a politician say the Black, and then he'll come right back and say Afro-American, and he'll come right back and say minority, start asking yourself, how can you be Black, Afro-American, and minority like you're talking to the same people?
Great point. Great point. Anybody want to pick up on subsection E?
I can. The provisions of this title shall not apply to a private club or establishment not in fact open to the public, except to the extent that the facilities of such establishment are made available to the customers or patrons of an establishment within the scope of subsection B. So section 202, all persons shall be entitled to be free at any establishment or place from discrimination or segregation of any kind on the ground of race, color, religion, or national origin, if such discrimination or segregation is or purports to be required by any law, statute, ordinance, regulation, rule, or order of a state or any agency or political subdivision thereof. Section 203, no person shall withhold, deny, or attempt to withhold or deny or deprive or attempt to deprive any person of any right or privilege secured by section 201 and 202, or intimidate, threaten, or coerce, or attempt to intimidate, threaten, or coerce any person with the purpose of interfering with any right or privilege secured by section 201 or 202, or C, punish or attempt to punish any person for exercising or attempting to exercise any right or privilege secured by section 201 and 202. I mean, this just, like we just mentioned, it's just very detailed in regards to what the message that they're trying to get by.
Chief Quiet Water, on that section you just read, what came to my mind was sports teams. Tiger Woods did that, where those are private golf clubs. And so, you know, they didn't have to desegregate. It was the world media, because he was so good. Those Europeans had to let him into those country clubs.
Okay.
Same logic with basketball, baseball, and football. Those are private organizations. So here you are 60 years later after integration, still saying, why ain't there no black head coaches?
Right.
No black owners. You don't have to, because it's private.
Wow.
Even though it's private.
Didn't think about that. Okay. Section 204A, whenever any person has engaged or there are reasonable grounds to believe that any person is about to engage in any act or practice prohibited by section 203, a civil action for preventive relief, including an application for a permanent or temporary injunction, restraining order, or other order may be instituted by the person aggrieved. And upon timely application, the court may, in its discretion, permit the Attorney General to intervene in such civil action if he certifies that the case is of general public importance. Upon application by the complainant, and in such circumstances as the court may deem just, the court may appoint an attorney for such complainant and may authorize the commencement of civil action without payment of fines, costs, or security. Okay, B, in any action commenced pursuant to this title, the court in its discretion may allow the prevailing party other than the United States and reasonable attorney's fees as part of the cost, and the United States shall be liable for costs the same as a private person. So what is that saying? In any action commenced pursuant to this title, the court.
Yeah, when you go back to permit the Attorney General to intervene in such civil action if he certifies that the case is of general public importance.
Okay,
If it ain't a lot of noise being brought up about it, the Attorney General really have to get involved. And then the courts, when they say section B, in any action pursuant to this title, the court in its discretion. That means they may accept a claim being filed or they may not.
Right.
How much dust the prisoner of war kicks up about the matter.
And so again, it's favoring how they want to handle it. They can totally ignore it, or they can be nice and you know, grant you some type of protection. But in most cases, is they totally just ignore, basically. Okay. Section C, in the case of an alleged act, let me see. In the case of an alleged act or practice prohibited by this title, which occurs in a state or political subdivision of a state, which has a state or local law prohibiting such act or practice and establishing or authorizing a state or local authority to grant or seek relief from such practice or to institute criminal proceedings with respect thereto. Upon receiving notice thereof, no civil action may be brought under subsection A before the expiration of 30 days after written notice of such alleged act or practice have been given to the appropriate state or local authority by registered mail or in person, provided that the court may stay proceedings in such civil action pending determination of state or local enforcement proceedings. D, in the case of an alleged act or practice prohibited by this title, which occurs in a state or political subdivision of a state, which has no state or local law prohibiting such act or practice, a civil action may be brought under subsection A, provided that the court may refer the matter to the Community Relations Service established by Title X of this act, for as long as the court believes there is a reasonable possibility of obtaining voluntary compliance, but for not more than 60 days. Provided further that upon expiration of the 60-day period, the court may extend such period for an additional period not to exceed a cumulative total of 120 days if it believes that there exists a reasonable possibility of securing voluntary compliance. Okay. Do you have something?
Yeah, if I could just make one, but that's why you always see these organizers trying to get our group of people out in the streets protesting. Basically, what I'm getting from what's being said here is, if there's not enough push behind whatever happened, court isn't gonna move. Now we're at a place where after George Floyd and the federal government didn't move because you didn't get a George Floyd Act. You didn't get qualified immunity ended, which you've now seen because the momentum was co-opted by the fake Black Lives Matter group and the fake Antifa group that you no longer hear about. They pretty much sucked the energy out of the room that we were initially feeling and having. Now those same states have turned around and they have put statutes in place. There is no law. They put codes and statutes in place that you can be ran over by somebody if you impede traffic. So what's happening now is you're not getting us mobilized in the streets anymore for these murders. So that allows the court, the federal government, and local municipalities to just keep brushing this shit under the rug. It's like you have to do too much to get shit done.
Right.
That's kind of where we are now. Like, no, it's time out. We're not marching. We're not coming down here talking about no justice, no peace, because nobody else has to do. The Asians didn't have to do that when they got shot in Atlanta 2 years ago.
Right.
7 people got killed. 30 days later, they got laws. You got illegal immigrants, not even citizens. They don't go to jail for driving without a license. They can work jobs and not pay withholding taxes or taxes off their paychecks, and they're allowing them to vote. And our group is sitting here not realizing the plays that's being run on them. I'll stop right there.
No, that's great. That's a great point, because yeah, it just shows the amount of stuff you have to go through. Like you said, have to drum up enough noise or kick up enough dust for it to become, national news. And then we might move forward with criminal or even civil charges, like you said. In this case, again, highlight Breonna Taylor. That happened March or February of 2020, and didn't get any type of movement in regards to like a court hearing until July, August of that year. So they're already showing, we'll extend, 60 days if you all can, voluntarily come to an agreement. We'll extend to 120 days to see if you all can, settle this shit amongst yourselves. But if not, then I guess we'll have to do a little bit more extra activity. But again, like you just highlighted, Chief Alligator, why does our group have to do all of this? I think it just, further, again, just, I mean, at this point, guys, if you all don't realize who we are underneath this system, then I'm not sure what else we need to provide for you. No other group has to do as much stuff, follow as many procedures, vote in as many elections to get even an inclination of something might be given to you, versus other groups who, you know what, we chilling, nobody is pandering or pondering for our vote. We understand our leverage in this situation, so we'll get shit done. But you as the American, no, you have to shuck and jive for, you know, at least 60 days, and then we might give you something.
Yeah, just to even be considered or even talked about and still don't get results. I mean, just, you know, nothing still in the end.
Absolutely.
I'll do the next section. Where we at? Section 205.
Yeah.
The service is authorized to make a full investigation of any complaint referred to it by the court under section 204D and may hold such hearings with respect thereto as may be necessary. The service shall conduct any hearings with respect to any such complaint in executive session and shall not release any testimony given therein except by agreement of all parties involved in the complaint with the permission of the court. And the service shall endeavor to bring about a voluntary settlement between the parties. So we're talking court proceedings right now, court operating procedures. 206, whenever the Attorney General has reasonable cause to believe that any person or group of persons is engaged in a pattern or practice of resistance to the full enjoyment of any of the rights secured by this title, and that the pattern or practice is of such a nature and is intended to deny the full exercise of the rights herein described, the Attorney General may bring a civil action in the appropriate district court of the United States by filing it with a complaint, one, signed by him or in his absence, the acting Attorney General, two, setting forth facts pertaining to such pattern or practice, and three, requesting such preventative relief, including an application for a permanent or temporary injunction, restraining order, or other order against the person or persons responsible for such pattern or practice, as he deems necessary to ensure the full enjoyment of the rights herein described. I'm going to take it right back to the first video Chief Biko played today, where the Anti-Defamation League, which is Jewish owned and controlled, has said that the militia has already infiltrated the public sector. This is why you don't have attorney generals in court, whether it be at the state level, the county level, or municipalities, implementing none of this shit. Because your attorney general is active militia. You see what I'm saying? So here we are. And then they never disclose who these militia public servants are.
Correct.
But all you got to do is just, does it pass the acid test? Look at the murders that have happened. Are these attorney generals stepping up and filing their own personal claims on behalf of these people? No. Who you see is Crump, who's a civil attorney. He's not criminal. He swoops in out of the night and he's gonna get you a settlement with a gag order attached to it. You can't say shit about it now after we give you this fiat. So I just wanted to throw that in, that infiltrated. I mean, you don't even know who's militia and who's not, but just look at the attorney generals that aren't fighting for you when shit happens to you. Look at the districts that aren't fighting for you.
It's a great point, because that'll just speak for itself. A lot of these people in these different sections and sectors of this government have been there for years. And like you stated, none of them have fought for you. So it's pretty clear to me, should be pretty clear to the viewer. If not, again, showing that that initial video with the Anti-Defamation League is stating what 38,000 members were pulled up on that list. A lot of them in different sections and sectors of this government. Again, Attorney General, if you don't have them vouching for you or filing these complaints, I mean, if the shoe fits, I'm pretty sure they're active militia or part of it. So yeah, this is all good as far as the procedures, but again, at the end of the day, we know this system, this government is infiltrated.
How long is Section B?
Yeah, to this period, yeah.
I'll do it real quick because
Okay.
it's 8 o'clock. Any such proceeding, the Attorney General may file with the clerk of court, with the clerk of such court, a request that a court of 3 judges be convened to hear and determine the case. Such request by the Attorney General shall be accompanied by a certificate that, in his opinion, the case is of general public importance. A copy of the certificate and request for a 3-judge court shall be immediately furnished by such clerk to the chief judge of the circuit, or in his absence, the presiding circuit judge of the circuit in which the case is pending. Upon receipt of the copy of such request, it shall be the duty of the chief judge of the circuit or the presiding circuit judge, as the case may be, to designate immediately 3 judges in such circuit, of whom at least one shall be a circuit judge and another of whom shall be a district judge of the court in which the proceeding was instituted, to hear and determine such case. And it shall be the duty of the judges so designed to assign the case for hearing at the earliest practicable date, to participate in the hearing and determination thereof, and to cause the case to be in every way expedited. An appeal from the final judgment of such court will lie to the Supreme Court. They took the word right out my mouth with the last sentence. It was sounding like a court of appeals. From my experience, having gone through the court process, the Court of Appeals is a panel of 3 judges. So basically, look how high you have to go within the state's court structure. You understand? Once that Attorney General files that complaint, that's automatically at the Court of Appeals level. And if you don't like what those 3 judges come out of that appeal court hearing with, then you have to go to the highest court within your state, which would be the Supreme Court. But again, getting that Attorney General to do that, if I go back to Ahmaud Arbery on my final statement, Ahmaud Arbery had multiple district attorneys never willing to file murder charges on the McMichaels. So it shows you how militia being infiltrated within the court system, how that backfires. If that dumbass redneck wouldn't have uploaded that video on Facebook, Ahmaud would just be dead. Because even when that district attorney saw that video, she said, I don't see nothing wrong. That's my closing comment.
Right. And the fact, like you said, in that the Defamation League's video, the fact that they can openly say that there's 38,000 public officials that are oath keepers, even though that video may not have gotten a lot of views, and I know definitely not by us, but the fact that they can just say that and just leave it right there. Just disclosing the fact that there's 38,000 people that are oath keepers and just leaving it right there. Nothing comes after that, nothing, like it's just okay and you need to accept it and just move on, and things are just the way that they're going to continue to be. And also the fact that most people, I didn't even know about the Defamation League and, what it entailed and what they supposedly have the power to do. So again, it comes to us lack of knowing things.
All great points. All great points. I think in closing, what this y'all just highlighted to me is just, again, how much we have to go through in order to just have a chance of any type of justice within this system. Again, Civil Rights Act is supposed to be for, quote unquote, Black people. But again, we haven't gotten many wins within this act or within these acts for quote unquote Black people. So again, it's just showing the level of barriers we have to cross just to get things even settled within this system. And then even once we do make it to a certain area, okay, now if you don't like what the 3 judges just said, now you have to take it up with the Supreme Court. So again, just shows the amount of work that our group has to do that no other group has to. Because again, these civil rights are made for who? The Negro, the colored, or supposedly was made for the Negro, the colored, the Black. But again, nothing is actually coming from these acts for the Negro, the colored, the Black, minority, whatever reclassification term this government uses for our group of people now. So that's pretty much just what it highlighted for me. So with that, we know where we stopped off. So next week, hopefully we have a good little surprise for the viewer. Again, if you have any questions, if anything we just went over, just isn't sitting right, engage, comment, we love to, answer any questions, provide the documents, provide exactly what we're looking at, and go over this stuff with you. Because again, we all need to know this knowledge, as Chief Quietwater stated. Because the lack of this knowledge, it obviously shows. How many of us, within school said, yeah, the civil rights is for, voting, or it's for Black people. But again, and I didn't do it today, but we'll definitely do it another time. Do a quick search, see if we find, Black, Negro, anything that we just saw in that Jim Crow laws of how they're specific, and see if, those terms pop up in the Civil Rights Act. They won't. So again, how can we say that these are actually for us if they're not being specific that it is for us? So I'll just leave it at that. And next week we'll definitely have a good show. Hopefully have a little surprise in the midweek to show exactly what we're got cooking up for you all. But again, like, share, subscribe, and then comment, engage.